Yes, in this lecture we will continue to see the charitable trusts. As we have seen in the first lecture, we have seen the creation of charitable trusts by way of express trust or constructive trust, or finally we have seen de facto trust. Charitable trust must fulfill two requirements. The first one, it should be for charity. That's one of the very important things. What is charity? That is defined in section 99(1). And also it is for the benefit of general public or section of general public. These two distinct qualifications shall be applicable in the case of charitable trust. If the trust is created for charity, but it is not for the general public, but it is for the private individuals, it is not a charitable trust. But it is a valid trust, but it is private trust. Now here we will see the charities. Today in this lecture we will define what is known as charity. As we have seen, section 99 of the trust ordinance provides that the expression charitable trust includes any trust for the benefit of the public or any section of the public within or outside Sri Lanka of any of the following categories. Then when you say the charitable trust, it may be created by express trust or constructive trust or de facto trust, but it should be a trust for the benefit of public, or it may be for the benefit of any section of the public. It may be within Sri Lanka or even outside Sri Lanka. But whatever it is, any of the following categories, that's known as charities. The first one given here, the trust for the relief of poverty. It's very important that if a trust is created for relief of poverty, and also it is for the benefit of public or section of the general public, then it is known as charitable trust. Then the second one, B paragraph, the trust for the advancement of education or knowledge. Third one, advancement of religion or maintenance of religious rites and practices. Finally, this is an open clause, trust for any other purpose beneficial or of interest to mankind, not falling within the preceding categories. Then it is known as charity. It is known as charity. Then from this section 99, subsection 1, these charitable trust should be for the benefit of general public or section of the general public, and also it is for the charity specified in section 99. It may be for the relief of poverty, advancement of education or knowledge, or advancement of religion, or the maintenance of religious rites and practices, or any other purpose beneficial or of interest to the mankind, not falling within the preceding categories. Now we will see some other place also these charitable matters defined. When you see the section 34 of the Companies Act 2017, where the registrar is satisfied that an association about to be formed as a company limited by guarantee is to be formed for promoting commerce, arts, science, religion, charity, sport, or any other useful object, and intends, so second condition, intends to apply its profit, if any, or other income in promoting its object, and also third condition, to prohibit the payment of any dividend to its members. Now when you see this one, the Registrar General or the Registrar of Companies must satisfy following things. The first thing is an association about to be formed as a company but limited by guarantee, that's the general company, is to be formed for promoting commerce, arts, science, religion, charity, sports, any other useful object. Then charitable is there. In addition to charity, religion there, science there, arts there, and commerce and sports, any other useful subject, or that also open. In addition to that, Commissioner of Company, Registrar of Companies must satisfy that intends to apply its profit or any other income promoting its object. Even though it is limited by guarantee and it is a social service organization, but if the company earns income or profit, that should be utilized for the promotion of same objects. And also, in addition to the third condition, the company should prohibit the payment of any dividend to its members. Then the registrar may, by license, direct that association be registered as company limited by guarantee without addition of words limited to its name, and also association may be registered accordingly and shall on registration enjoy all the privileges and, subject to the provisions of this section, be subject to all obligation of limited company. Then here the important part here, the definition given for the charitable organization, because generally when you speak about these matters, charity or whatever, it includes so many matters. As we have seen in the Companies Act, Companies Act permits for the promotion of commerce, arts, science, religion, charity, sports, and any other useful object. Now we will see the definition given in Inland Revenue Act 2017. Charitable purpose means a purpose for which for the benefit of public or section of the public in or outside Sri Lanka. The similar words appear in the trust ordinance also. When you see this section 99 of the trust ordinance, any trust for the benefit of public or section of the public within or outside Sri Lanka. The same way here also, charitable purpose means the purpose for which for the benefit of the public or section of the public in or outside Sri Lanka, fine. Similar words appears in both places. Similar words appear in both places in the Inland Revenue as well as in the Trusts Ordinance. Then we will see the category, including following category. Including following category. Now when you say here, when you read this section very carefully, in both places, in the Trust Ordinance as well as in the Inland Revenue Act 2017, the charitable trust includes. That means there are some more matters can be put into the charitable trust, because charitable trust includes these things. Some other matters also there to include. But here in the Inland Revenue Act 2017, charitable purposes means, then it is something, definition is closed. This is a charitable trust, not any other things. But in terms of Trusts Ordinance, charitable trust may include some more things. That's keep it in your mind. Other than that, purpose for the benefit of public or section of the general public, and within Sri Lanka or outside Sri Lanka, similar words used in both enactments. Including following category, relief of poverty, here also section 99(1) for the relief of poverty. Advancement of education or knowledge, here also advancement of education or knowledge. Other than by institution established for the business purpose or by institution established under Companies Act. Then even though the institution established for business purpose, it can't be charitable purpose. If the institution established under Companies Act, it can't be charitable institution. Then here the activities for the protection of environment or eco-friendly activities. That's not in the Trusts Ordinance, but paragraph D of section 1, subsection 1 of section 99 of the Trust Ordinance provides that trust for any other purpose, beneficial or of interest to the mankind, that includes anything and everything. But here categorically said that activities for the protection of environment or eco-friendly activities. Advancement of religion is given in the Trust Ordinance also. Advancement of religion and maintenance of religious rights and practices. That's fine. That's more or less same provision or similar provision is in the Trust Ordinance. Then finally, any other purpose beneficial to the community not falling within any of above category, more or less similar provision. Then when the Companies Act is something more wider than the Inland Revenue Act as well as Trusts Ordinance. When you compare this Trust Ordinance and the Inland Revenue Act definition for charitable trust or charities or charitable purpose, it's more or less similar definition given. Now, in addition to that, you would have seen some cases where the Parliament enacts laws. In terms of Standing Order 53, a trust fund may be incorporated by an Act of Parliament. If such fund or trust fund created under section 5 of the Trusts Ordinance. However, the names of certain incorporation include the word trust, but in reality it is not a trust fund under the provisions of Trusts Ordinance. For example, Hampton Village Sri Lanka Trusts Incorporation Act number 3 of 2010, Zam Trust Incorporation Act number 72 of 2009. Even though in the name of these institutions the word trust is added, but still these are not under provisions of Trusts Ordinance. If these organizations, if they formulated or created a trust under section 5 of the Trust Ordinance, then it may be governed by provisions of Trust Ordinance. Otherwise, these trusts governed by provisions of this Act of Parliament. Now we will see the Charities Act 2011 of United Kingdom. For the purpose of law of England and Wales, the charitable purpose is a purpose which falls within subsection 3.1 and it is for public benefit. It is for public benefit. But when you see this history of this English law, it's a long history. First, there's a fourfold classification of charitable trusts enunciated by Lord Macnaghten in the case of Commissioners for Special Purposes of Income Tax versus Pemsel in 1891. But even this classification made by Lord Macnaghten based on the classification used in Charitable Uses Act 1601. 1601. This classification was derived from the preamble of Charitable Uses Act 1601. More than 400 years ago, the charitable trust defined. But time to time the definition changes, but after several decades of discussion, the UK Act defined the charity in 2011. The first thing is it should fall under or within the section 3.1 and also it is for the benefit of public. When you see the list here, a purpose falls within the section 3.1 if it falls within any of the following description of purposes, then it is known as charity. As we have said in Sri Lanka Trust Ordinance, even though similar provisions are there, but it is well wide in the scope of charity. The first one, prevention or relief of poverty. But in Sri Lanka, only trust for the relief of poverty is recognized. But in UK now, in the present context, in 2011 UK Act, Charities Act widened the scope of charity and said that prevention or relief of poverty. Advancement of education, but here in Sri Lanka, advancement of education or knowledge. The third category, advancement of religion, but in Sri Lanka, advancement of religion plus maintenance of religious rites and practices. J.M. Hooray cited the reason for this one, because in Christianity there is no such religious rites and practices, but in Buddhism, Hinduism and Islam there are so many or huge number of religious rites and practices. That's why when we drafted this trust ordinance, the section is something widened because of the situation in Sri Lanka. The advancement of religion is enough for the Christianity. That's why in UK it said that advancement of religion. But in Sri Lanka, advancement of religion, in addition to that, maintenance of religious rites and practices also indicated. And advancement of health and savings of lives, that's not here at all. And advancement of citizenship or community development, advancement of arts, culture, heritage or science, advancement of sports, advancement of human rights, conflict resolution, reconciliation and promotion of religious and racial harmony and equality and diversity, advancement of environmental protection and improvement. The relief of those in need because of youth, age, ill health, disability, financial hardship or other disadvantage. And very important thing here, advancement, that's why I highlighted this part, advancement of animal welfare. This is first time in the law recognized in UK. Even though there were cases determined to recognize such advancement of animal welfare for the benefit of general public, but here it is for advancement of animal welfare is recognized, but still it should be for the benefit of public. Promotion of efficiency of armed forces of the Crown, of the efficiency of the police, fire and rescue services or ambulance services. Any other purpose that are not within the paragraph A to L but are recognized by charitable purpose. Then the Charitable Commission in UK has the power to decide the specific matter is charitable or not. Therefore, in addition to the list of charities, in addition to that also the power is given to the Commission to determine whether the specific act is charitable or not. And also in UK Act, paragraph C, religion includes religion which involves belief in more than one God, and religion which does not involve belief in God. Because it depends on the belief. Nobody can prove the existence of the God. If you believe that there's a God, that's also religion. If you don't believe that in a God, that's also religion. But finally, you have some sort of belief regarding the God. The God is there, that's also one of the belief. God is not there at all, that also belief. That's why the religion includes a religion which involves belief in more than one God, or the religion which does not involve belief in God. The Lord Macnaghten, in the Income Tax Commissioner versus Pemsel case, cited those fourfold classification of charitable trusts. The fourfold classification of charitable trusts enunciated by Lord Macnaghten in Commissioner for Special Purpose of Income Tax, or simply you can say Income Tax Commissioner versus PEMSEL, 1891. As I told you at the beginning, this classification was derived from the preamble of the Charitable Uses Act 1601. Now in this fourfold classification of charitable trust, the Lord Macnaghten defines to some extent the term of charity. Charity in its legal sense comprises four principal divisions: trust for the relief of poverty, trust for the advancement of education, trust for the advancement of religion, and finally trust for any other purpose beneficial to community, not falling within any preceding heads. Now here the trust ordinance 100% reflects the Macnaghten rule. When you compare the provisions of section 99 of the trust ordinance with the Macnaghten rule in Income Tax Commissioner versus PEMSEL, is more or less similar wordings used. The present Charities Act 2011 in UK widened the scope of the charity, definition of charity. But in Sri Lanka, it has been pointed out in relation to the word includes in section 99 that the effect of this word in a statutory definition is prima facie. The enumeration following words is not exhaustive. That means you can bring some other matters within the scope of section 99, subsection 1. Now this is, now you may have understood the definition of charity in different laws. What we have seen here, first one we have seen the charities definition or the charities divisions given in section 99. Then we have seen Inland Revenue Act. Now thereafter we have seen the Companies Act. In addition to that, we have seen the Charities Act 2011 of United Kingdom. And finally summarize, even our law is something like open because of the word includes. Now we will see what is known as benefit of the public or any section of the public. As we have seen, a trust to be a charitable trust that should fulfill the requirements of charity and benefit of the general public or the section of the public. Now we will see the benefit of public or any section of the public. The public benefit rule is very important aspect in a trust to qualify as charitable trust. Again I emphasized this matter. The trust to qualify a trust to be a charitable trust, the basic rule is it should satisfy two distinct qualification or requirements. First one, the charity that we have seen now, it should be for the benefit, for the relief of poverty, or for the maintenance of, for the advancement of education or knowledge, or for the advancement of religion or maintenance of religious rites and practices. Finally, trust for any other purpose beneficial or interest to the mankind or human beings. Those are charity, the division of charities. But here, now we see that the benefit of the public or section of the public. The public benefit rule is the very, very basic aspect of charitable trust. That's why here we said public benefit rule is very important aspect in a trust to qualify a charitable trust. The lack of public benefit in a trust, it can't be charitable trust. But it is a valid trust, but it is a private trust. In this case, Compton case, where a trust for the education of descendants of 3 named persons was held not to be a valid charitable trust, because it is for the promotion of education. Fine, it is within the charity divisions. Therefore, if the trust for the promotion and education, there is no big issue, that's a charity. But then we must see whether it is for the public benefit. Descendant of 3 named person, can you say it is public? No, we can't say it. This group of people are individuals of or relatives of the author of the trust. That's why descendants of 3 named person was held not to be a valid trust, but it may be private trust, because beneficiaries are defined by reference to the personal relationship, and the trust therefore lacked the quality of public trust. Because if it is a public trust or the charitable trust, it should be for the benefit of general public instead of descendant of 3 named persons. The trust was in reality a family trust, not for the benefit of section of the. Sometimes one may argue that it is section of the public, but it can't be, because the descendant of 3 named persons then says there may be some sort of personal relationship. Because of the reference of these personal relationship, it lacks of public benefit. Now we will go to next slide and see this case. Oppenheim versus Tobacco Securities Trust Company, where the trustees were directed to apply funds in providing for the education of children of employee or ex-employee of British American Tobacco Company. Now, first place, as we have seen, there are 2 distinct requirements in relation to charitable trust. First one, it should be a charity. Second one, it should be for the benefit of public or section of the public. Here, trustees were directed to apply the fund in providing education. Stop with that first. Providing for the education, that means advancement of education. See in the charities whether it is recognized, fully recognized. Advancement of education is one of the divisions of charity. Then there is no big issue. There is pure idea is promotion or advancement of education is charity. Then we must see whether there is a public benefit. Children of employees or ex-employees of British American Tobacco Company. The employees numbered over 110,000. There's a big number of employees. Then it is applicable to large number of group, but still employees numbered, or this is something over 110,000. The majority of the House of Lords held that although the group of person indicated was numerous, the nexus between them was employment by particular employer, and this trust did not satisfy the test of public benefit. Therefore, whether the trust is created for small group of person or the big large number of group of people doesn't matter. It is immaterial at all. But we must see whether it can be said as general public or section of general public. In the Oppenheim case, even though the number of beneficiaries more than 110,000 doesn't matter. If there's a connection in between author of the trust and the beneficiaries, then they cannot be categorized as public or section of the public. Therefore, it is a private, it can be a private trust, but it can't be charitable trust. An aggregate of individual ascertained by reference of some personal tie. For example, blood. As we have seen in the first case, there's a blood connection, descendant of 3 named persons. Then there's a blood connection. There may be a contract. Contract in the sense relations of particular individual. That's we have seen. The member of particular family or member of particular association. The Oppenheim case, we can say the particular association as a company. Tobacco company, British American Tobacco Company is an association. They all are, the beneficiaries are more or less employees or ex-employee of such institution or firm. Therefore, the members of the particular association does not amount to the public or section of the public for the purpose of general rule. Because of that, now we must identify that. When you say that it is for benefit of the public, there should not be any connection between the author of the trust and the beneficiary. If the author of the trust and the beneficiary is connected by way of personal ties, some blood or the contract or relationship or members of particular, whatever it is, then it does not amount to the public or general public for the purpose of creation of charitable trust. On the other hand, if the trust is construed in such a way as merely to grant a preference to a limited class such as employees or relations, the trust will qualify as charitable trust. Now, in the Oppenheim case, the trust is created or the trust created for the benefit of employees and ex-employees. It is not a preference, because Oppenheim case, in the case of Oppenheim, trust is for the education of children of employees or ex-employees of the British American Tobacco Company. The beneficiary, the employees were more than 110,000, then that means beneficiaries may be more than that amount, the huge number. But it doesn't matter. If the beneficial interest goes to the beneficiaries who are more or less something connected to the author of the trust in personal tie, then it is not valid charitable trust. But suppose if the preference given, now say suppose in the Oppenheim case, suppose the trust is created for the promotion of education, but the preference should be given to children of ex-employees and ex-employees of the company, then it may be valid trust. That's why here we say that we differentiate. If the preference is given to some people in the whole trust, the beneficial interest, it doesn't matter. It may be valid charitable trust. That's why here, on the other hand, if the trust is construed in such a way, merely grant of preference to a limited class, such as employees or relationship, then the trust qualifies as charitable trust. In this case, the next case in Hodgkin versus Hodgkin's will trust case, the testator instructed that her residual estate should be held by her trustees as a fund for promotion and furtherance of commercial education. Furthermore, the persons eligible as beneficiary under the fund shall be the persons of either sex who are British born subject and etc. Moreover, in selecting beneficiaries, it is my wish that the trustees shall give preference to the employees of JB and Company or the members of families of such employees. Here, the difference between the Oppenheim case and this case, in the Oppenheim case, the beneficial interest should go to the children of employees, not any other person. But here, the preference given to the employees of JB and Company and members of the family of such employee. The main issue was whether the trust was in the public benefit or therefore it is charitable trust. It may be it amounts to the charitable trust. But the court held that the trust was charitable trust for the public benefit. Because here the difference between two cases, Oppenheim case and this case, The open claim case, the beneficial interest should go to the children of employees, but here only the preference given to the employees. The preference given, the preference in the sense it is acceptable, but the generally, in the second case, the beneficial interest should be given to the general public, but still the preference may be given to the employees. Therefore, it satisfies the requirement of public benefit. Therefore, it is charitable trust. Now here in this case, Martin case, where a trust to establish home for old people with a right for either both of testator's daughters to reside there was held not to be charitable. Because again, here not that preference given here in this case, the Martin case, even though it is the trust was created for the benefit of old people, but finally as a right given to the daughters of testator to reside there. Therefore, it is not charitable trust. Even though requirement of public benefit is must, it may differ from head to head specified in section 99. That we will see later, because when you see the relief of poverty, public benefit is something different from other heads like promotion of education, advancement of religion, all other things. Differently we must apply, because relief of poverty is one of the basic thing in the community. That's why here we say that even though requirement of public benefit is must and mandatory, it may differ from head to head specified in section 99. Then there is a dual test to be satisfied. The purpose of the trust must fall within the legal definition of charity. It may be charity, but it should come under legal definition of charity. Second thing, it should be for the benefit of public. If it is to be valid charitable trust, then only it is valid charitable trust. Now we will see here Commissioner of Income Tax versus the trustees of Abdul Kafur Trust. HMG Fernando J. thought that section 99 does not require a trust to be solely does not require trust to be solely for the benefit, for the public benefit, so that a trust which is essentially and substantially for the benefit of public or the public benefit may reasonably be considered fall within the definition. Once again, Commissioner of Income Tax versus trustees of Abdul Kafur Trust. The court held that, or the court stated that section 99 does not require trust to be solely for the benefit of public. Then what? So that a trust which is essentially and substantially for the benefit of public may reasonably considered fall within the definition. Then the public benefit in the sense the trust always essentially and substantially for the benefit of public. H.N.G. Fernando J. stated that in some detail to define the words public or section thereof, the test of the public benefit laid down by the House of Lords in Oppenheim versus Tobacco Securities Limited has been adopted in Sri Lanka. Then there should not be any relationship, maybe by blood or maybe by contract or maybe by employment or maybe by association, whatever it is. Then it can't be charitable trust. According to this test, an aggregate of individuals ascertained by reference of some type, example blood or contract, such as the relationship of particular individual or family or employees of particular firm, do not constitute a section of the public. Because sometimes one may argue that the selected individuals in large number may be categorized as section of the public, but it does not constitute section of the public. That's why here, according to this test, the aggregate of individuals ascertained by a reference of some type anyway, blood or contract or relationship of particular individual or family or employees of particular firm do not constitute section of the public. In the Abdul Ghaffur case, a trust for the deserving youths of following Islamic faith, which contained a discretion to the trustees to give preference to the descendant of testator's family, was held to be not for the benefit of public. Abdul Ghaffur case, in the Abdul Ghaffur case, English case, Horton trust was not followed. In Horton case, the trust case, an educational trust for the British-born subjects contained a clause that in selecting beneficiaries, preference should be given to the employees and members of their family. This trust was held to be for the benefit of public. But in Sri Lanka, there are different minorities, groups and religions. So a trust for the group may be qualified as valid trust. Therefore, even in the Abdul Ghaffur case, it is for the benefit of certain group. Therefore, it may be valid charitable trust. But still, when you see these English principles, just we will see that also now. In the English law, the trusts fell within the first 3 of 4 heads: charity identified by Lord Macnaghten in Pemsel case, trusts for the relief of poverty, trust for the advancement of education, and trust for the advancement of religion enjoyed the benefit of presumption that they were established for benefit of public. The strength of presumption varied across 3 categories. In the case of trust for the benefit, for the relief of poverty, it was virtually impossible for the presumption to be rebutted, save where the trust was for the benefit of an extremely small number of persons all connected with the said law. In the case of trusts for the advancement of religion, and presumption was not rebutted merely by reason of fact that the trust was for the benefit of a relatively small group of persons restricted both by their beliefs and by where they worshipped. Thus, what was known as a class within the class was compatible with the public benefit. As we have seen in the Ghaffur case, it is for the Islamic youths, but still preference given to the certain people. The class within the class was compatible under English law. That's why what is known as a class within the class was compatible with the public benefit. In contrast, in the case of trust for the advancement education, the presumption was rebutted whenever the trust was for the benefit of a group of persons who were ascertained by a reference of some personal type. On the other hand, in the case of trusts which fell within the Lord Macnaghten fourth head, trust for other purposes beneficial to the public, there was no such presumption, and existence of public benefit had to be positively demonstrated. This was a history, but presently, now all the charitable trusts need positively demonstrate the provisions of public benefit to prove that trust come within the purview of section 99. Therefore, now the clear idea is all the charitable trust, whatever it is, it may be for the relief of poverty, or maybe advancement of education or religion, or whatever it is, need positively to demonstrate the provisions of public benefit. Now, what we have seen up to now, we have identified and understood the charity and public benefit. These are the core issues in relation to the charitable trust. First place, the trust for the charity specified in section 99 subsection 1 of the Trusts Ordinance. Second thing that we have seen, the public benefit or public interest, or the section, it is for the benefit of section of public. First place, we have seen in different laws govern or specify different definition for charitable or charity or charitable purpose. For the purpose of understanding, we have seen, or we have done the comparison between the Trust Ordinance and Companies Act, between the Trust Ordinance and Inland Revenue Act. When you see all three acts or the legislative enactments, the Companies Act is widening the scope of charity. But next to that, we can say even the Inland Revenue Act 2017 define the charitable purposes in a different way, which includes many items in the definition. Whatever it is, now for the purpose of learning the correct understanding under charity, we must see the section 99 of the Trust Ordinance. The charitable trust includes any trust for the benefit of public or section of public. That's the first thing, and other 4 heads. For the relief of poverty, for the advancement of education or knowledge, and advancement of religion and maintenance of religious practices, rites and practices. Finally, there's an open clause here, anything, any purposes beneficial or the interest to the human beings, not falling within the. And we have seen, in addition to that, we have seen the Charities Act of United Kingdom 2011. It has a long list of charities. In addition to that, there is an express provision for the advancement of animal welfare also there. Whatever it is, that should be for the benefit of public or public. But here in Sri Lanka, we have seen benefit of public or any other section of the public. If there is a personal connection between the author of the trust and beneficiaries, by way of blood or contract or institution or association or employees or whatever it is, that cannot be charitable trust, because those members cannot be recognized as public, but those are private individuals. In that case, it is a valid trust as private trust, but it is not a valid trust as charitable trust. Now we will stop this lecture with this one, and we will see in the next lecture the trust for relief of poverty. Then we will see one by one all these charities and the public benefit of in relation to the different heads. Now we will stop with this one. Thank you very much.